Good evening, everybody, and thank you so much for logging on to our Netstrata owner webinar this evening, where we're presenting the changes to the New South Wales Strata and Community legislation. We thank you so much for your time on logging onto our webinar this evening. Thank you for your support. Feel free, obviously, to use the Q&A function rather than the chat function in our Zoom room this evening. No question is out of bounds. Feel free to ask us anything, and hopefully we're well equipped to be able to fire off an answer or answer it live. So as I say, feel free to pop that into the Q&A as we go. This session is being recorded, so obviously just be mindful of that. That's fantastic. And just first and foremost, before we get started, just to introduce who we are. So you might have seen my head from previous webinars if you'd logged on previously. My name is Andrew Chunks. I'm the Learning and Development Director here at Netstrata. I'm joined by Joshua Barry, Senior Strata Manager here. G'day, Josh. Thanks for logging on.
G'day. Welcome, everyone. Thank you.
So tonight, basically, we're going to walk you through the changes to the Strata Schemes Management Act and Community Land Management Act and Development Act, etc., etc. There's a whole pile of stuff that will try and keep you awake as we go through all the changes to the various pieces of legislation, etc. But I will just kick it off by saying that this webinar is obviously for informational purposes only, and it shouldn't be constructed as legal advice. Obviously, we've read the amended bills of legislation, all that sort of stuff, and obviously formed our opinions and slides based on our expertise. However, it's not legal advice. So the information provided in this webinar is not a substitute for professional legal advice. So should you be looking for specific legal advice, obviously reach out and we can point you in the right direction. Okay, what we're going to cover this evening. So we're going to cover the journey in Strata. So where we've come as a sector, which is quite exciting that we've got a new bunch of reforms on the precipice of being launched, and we'll walk you through what that looks like. So phase one of the New South Wales Strata reforms is currently, or has currently been passed at Parliament, waiting to basically become law. So we'll walk you through where that's currently at. We'll also walk you through the phase two of the New South Wales Strata law reform. So what that looks like and the sorts of things that the government are looking at. And obviously how this affects your scheme. We'll again open up for some Q&A time. Following that, again, feel free to pop your questions in the Q&A and Josh or I will get you there. We'll start off with a question. So we'll get you to warm up on the Q&A button there. So were you aware of the upcoming changes in the Strata legislation? So perhaps you could be a Strata nerd like me, and you follow these sorts of changes. You might be in a committee or in an owners corporation, or potentially you've listened to particular media outlets and you're aware of changes. Pop it in the Q&A. Have a little warm up. Let's see how we go. So no, there's quite a few people not aware there. Yep. Okay, we'll get on. There's a couple of questions already fired in there. Not a problem. No, not a problem. A few have heard. A bit of a mixed response there. So yeah, a handful have heard of obviously the changes, but there's quite a lot that haven't. So that is fantastic because that's what we're here tonight to walk you through, the changes. We're going to kick that off with talking about the journey in Strata. So where we've come from, and basically we'll walk you through legislatively, get the word out, Andrew, where we're heading thereafter. So my esteemed colleague is going to walk us through the history of the sector. So starting off with company title. So I'll hand over to you, Josh, to explain what this is all about and where we've come from as a sector.
Yes, thank you. Thank you, Andrew. Welcome, everyone, again. So yes, the history of the sector and all the legislation involved up until today. So company title was the first one to come into Australia. Basically, as it says there, this was around the sort of 1920s and the 30s, basically for Art Deco, heritage apartment buildings, that type of stuff. And there still are some today, especially sort of in the city, Darling Point, Potts Point, and the like. So company title is to do with basically there's no title, physical title in real estate, I guess you would call it. It's all about shares in a company in the form of a right to occupy a defined space. So yeah, instead of getting a certificate of title, you do receive a share certificate. So basically some of these can be, they can be converted. They just need to do a strata plan to get that on the strata title, which leads us to the next one, which came in the 60s. So this, obviously opposite to company title, allowed purchasers to have that legal interest in their property, so a physical certificate of title. So basically this allowed owners to hold that piece of land, have a certificate of title for that defined cubic airspace in their building. Okay, over to the community and neighbourhood and precinct association. So a few things there. Obviously, these do range in sort of smaller size into what you see on the screen. It can be very large indeed. So basically, there are associations that are made up from deposited plans, okay, individual lots that are sold and subdivided, and they have membership into that community scheme. So as you can see there are and oversee a mix of properties, landscaping, recreational facilities on one land allocation. So it could be a residential apartment next to that shopping centre, or a golf course, a playground, those types of things. And they are also connected with roads, cycleways, footpaths, those types of things. Okay, so you can have those sort of smaller community plans. It could be 10 to 20 lots. They could look like sort of normal houses, but they are part of a community scheme. And they just have sort of the road in the middle that they all maintain, and gardening and the like. And then obviously they do move on. They can be subdivided into sort of neighbourhood and precinct plans, which, as I mentioned, you see on the screen. So a few other things they can be part of, gyms, swimming pools, tennis courts, even marinas and that type of stuff. Okay, so they are sort of the three types that we've had so far. So here is a snapshot of the journey. Okay, so the Conveyancing Strata Titles Act formed in 1961. So basically before that, we did have the company title, as we mentioned before. So the New South Wales government actually created that framework. Was one of the first in the world, and many other countries followed, including Dubai and South Africa as well. So that was what was in place up until 61, till the Conveyancing Strata Titles Act came in. So that was sort of the framework that we work with for Strata. Now, we then moved over into the Strata Titles Act and Community Land Development Act around 1973. So this is where they had their own separate legislation, okay, and that's where community plans were first sort of acknowledged. Now, with you may have heard of the pre-1974 plans. So that's where, if you do have a structure which would be considered common property today. So example is a balcony door or something like that. If you had the balcony, obviously you'd own the balcony and inside the unit. That would be considered lot property and not common property like it is today, obviously depending on the plan and the line work. So that was in 1973. So the pre-1974 plans. We also had the community plan updated again in 1989. Okay, so that's when the changes came into the Community Land Management Act. We then moved on to the 96 Strata Schemes Management Act. So there were big changes there from that 1973 Act. Okay, so a lot of big changes there, which were in place up until 2015. Okay, and then back onto the community land management. So since 89, there were those further changes in 2021. Okay, so what we're seeing here, there's sort of changes to those acts sort of every 20 years, and then sort of every sort of 5, maybe to 8 years, these normally reviewed and those changes are made, like what's happening now. The amendments are done from the government, and yeah, we get time to sort of put them into place and learn what they're all about. Okay.
Fantastic. Thank you, Josh. And yeah, just to sort of add to that, obviously significant changes in the 96 Act. I was a strata manager in the 96 Act, and then obviously moving forward into the 15 Act, and quite a massive change. And probably the most significant change, obviously we've learned to appreciate it through COVID, is electronic meetings, being able to submit pre-meeting votes, and obviously, bringing the strata legislation up to sort of today's, happening. So currently, as Josh said, around about every 5 years, you see statutory reviews. So in 2020, 2021, the 15 Act was reviewed. So on the 30th of November 2016, the 15 Act was in place, and obviously 5 years from then, the state government did basically a review of the legislation. Now, from that review, the report was in November 2021, and there was 139 recommendations. So there's many changes and obviously some sort of particular parts of the legislation, just remain, the status quo. So the Strata Development Act and the Management Act obviously together govern the whole life cycle of a strata scheme. So basically from the inception of the scheme, from when it's a pile of dirt in the ground, all the way to completion, obviously transition into being an owner's corporation. So all that's been reviewed, and there's a number of things that we're going to walk you through. So 31 of the 139 reforms are recommended. So the current position is that law reforms have been approved by the Legislative Assembly and the Legislative Council, and we're basically just waiting on the ministerial assent and gazetting to become law. So that could be any day now, basically. So as you can see from the screenshot, you can see that the amendment bill, which covers the strata and community pieces of legislation that were reviewed, basically both passed by both houses. And what I mean by that is that was really phase one. So phase one pretty much was, items within the public consultation documentation that really didn't raise too many disputes. So obviously phase two will move into more sort of consultation, with the sector and obviously governing bodies, etc. And I'll walk you through that as we go. But I really want to sort of walk you through first and foremost phase one. So what phase one is all about. So what has been passed and will become law, as I said, in the likely to be in the coming days. So we'll start off with talking around the strata renewal process. So if you're not aware what a strata renewal is, it's basically where you've got perhaps an older scheme and a developer might take interest in that particular site in the view of redeveloping it. So for example, let's just for argument's sake say that you've got a 10-lot strata scheme built in the 1960s. The owners corporation have decided, look, it's too sort of far gone to start renovating. A developer comes along and basically, looks to purchase the lots within the scheme and obviously redevelop it. So it's called a strata renewal or a collective sale process. So the strata legislation 2015, there's a landmark change that basically changed the strata renewal process from being a unanimous decision, so 100% of lot owners needing to agree, to 75% of lot owners agreeing. So big change. And back then when the public consultation was occurring, obviously there was, debate around, if somebody is, does not want to leave their home, should they be forced, etc., etc. There's a whole pile of laws that got put in to protect them. And the issue is that, and the example I've got on the screen there is there's sort of so many pieces of legislation and laws to govern it that there wasn't a lot of successful collective sales because the laws were sort of too stringent. So basically, the strata renewal allows a collective sale or redevelopment of a scheme with the approval of 75 plus of the owners and includes safeguards, as I mentioned a moment ago, designed to protect, obviously, the consumer, the strata owner. So here's an example the government have put out there, and it did make the paper, one out there at Macquarie Park. So this particular one failed. More than 75% of owners supported a collective sale. However, there was a competing developer who bought lots in the scheme and obviously objected, basically forcing this particular collective sale process to fall over. And then basically with the tight confounds around the process, it basically had to all be started all over again. So the competing developer used safeguards to prevent success of the scheme, obviously drawing out the proceedings and obviously incurring costs. And there's no requirement to disclose the conflict of interest when raising objections. So the changes to the legislation will require those conflicts of interest to be put forward. So the cost in that particular example couldn't be recovered against the dissenting owner acting unreasonably. So what are the changes? So basically the changes, the strata renewal process will expand the disclosures and basically change how the courtroom will deal with costs of each party. Also extends operation of a strata renewal committee from 12 months to 2 years. So as I said before, there's quite a strict process to basically go through to make sure all checks and balances have been put in place in order to, for the courtroom or tribunal to basically say, yes, this strata renewal can proceed. Now, if you didn't do all the right things within a 12-month period, you basically have to start again. However, this has been expanded from 12 months to 2 years. So it's giving owners corporations of potentially older or dilapidated sites a little bit more time to obviously work through the process together. And also the changes permit the court to approve a strata renewal plan notwithstanding basically, minor procedural irregularities. So, if previously the process had to be followed to the letter of the law 110%, now, for example, you might have followed the process 96% of the way, and, they'll sort of give you the green light thereafter. So that is the way or the direction that they're moving. Also, a couple of other Development Act changes that I'll walk you through. So one of them is in relation to the units of entitlement. So if you don't know what a unit of entitlement is, it's basically, as the screen says there, the value. It's your share in the owner's corporation. So if you've got a total aggregate or share pool of 100, and let's say you've got a 10-lot strata scheme, you own unit 1 and it has 10 unit of entitlement allocated to it, then that particular lot has, basically 10% share in the owner's corporation. So every $100 that is raised, that particular lot would pay $10 towards it. It would also be that particular lot's voting right for, special resolution motions or motions determined by way of a poll vote. So the UEs are obviously quite important, and most of the complaints we get around units of entitlement are, people feel that, they're paying too much, potentially other apartments, etc., could possibly be larger, and the unit of entitlement may be lower, and those sorts of things. So the changes here, the UEs obviously are determined by qualified valuer on the base of market value. So when we say market value, at the time that the strata scheme is registered, each lot should be valued against one another at the time of registration, as I said. So if a strata plan, let's say again, 10-lot scheme, brand spanking new, is valued today, each lot is valued in comparison to one another. So introduced in 2015, obviously to provide a fairer basis for sort of assessing the level or voting rights than on developer sort of estimates. Previously, developer estimates, might have landed them in a bit of hot water, where owners' corporations, as I said before, potentially disagreed with, the way in which the units of entitlement sort of brought about. And obviously means all lots in the scheme need to be valued. So it's a much fairer change to have this done by a qualified valuer. Now, with obviously any change in the legislation, there's potentially things that don't work out or have unintended consequences. So there's a few things that they want to fix here around subdivisions, for example. So the valuer does not have to value all the lots in the scheme if the strata plan of subdivision involves common property. So sometimes we see a scheme that might be staged. So it might be 10 townhouses that are built and completed. There might be a development lot which then flows into another 5 or 10 townhouses, etc. And obviously, if there are elements of that subdivision that only involve common property, well, they're changing it basically that a valuer does not have to value all of the lots. Also, if the subdivision involves minor changes to common property, and in the valuer's opinion, if the changes don't affect the proportionate unit of entitlement, obviously they value the new stuff and they're not having to get through and revalue all of the older or existing lots. What does this do? Basically, significantly reduces the cost and administrative burden for strata owners. So where there are subdivisions, they're not having to come back and value, the other lots within the scheme. All right, moving on. So the Management Act, Josh was going to sort of walk us through a couple of things in relation to, special resolutions for original owners. So I'll hand over to you, Josh.
Thanks, Andrew. Yeah, so this is just a few changes, sort of new versus old, in the Management Act. So the first one we found is the original owners reduced vote by 2/3 for special resolution votes if they own more than 50% of the aggregate unit entitlement. Okay. Previously, any original owner, it would only be for management agreements and election of committees. Okay, so now obviously that will still be in place, but they've added that it's if the developer owns over 50%, they will only be allowed to have 2/3 of vote for any special resolution motion. Okay, that's at any general meeting. The next one is the Management Act, the developer documents. Okay, so the Section 16 documents, for any new buildings, there is legislation about what they need to hand over. Okay, so previously it'd be 48 hours before usually the first AGM. Yes, before the first AGM. These would include plans, specifications, warranty information. So things like occupation certificates, and initial maintenance schedules. So documents which state how what you need to service and maintain all the critical infrastructure in the building to ensure warranties and all those types of things. Okay, so that has now gone to 14 days and not 2 days like previously. Next, we have the AGM dates. Okay, so this is this will affect everyone in Strata, the Strata managers. So previously we'd have 7 clear days notice, okay, plus postage for any general meeting notice. This has now gone out to 14 days plus postage. Okay, so with postage, it's 7 working days, so it does not include the weekends. Okay, so usually we're looking around sort of 2.5 weeks currently to send an AGM notice out. So now we've got to add another week onto that. So just over 3 weeks for any AGM notice going out to owners. All right. Community land. So there's been a change to the community plan legislation as well. So previously 9, similar, well, the same as Strata, 9 members for a residential Strata committee was the same for community. So that's now increased to 15 for community lands, for community plans. So 15 members there allowed.
Yeah, and sorry, just to jump in on that one, for all our owners logged on, the proposed legislation, they were considering lifting the number of committee members, which you might find quite amusing, from 9 to 15 for Strata. And if any of you are on Strata committees, you might notice that when you have a Strata committee meeting, often you don't get a quorum because there's not enough people attending. So if you lift that number to 15, obviously your quorum number that you're required to form a meeting also lifts. So in community, I guess the difference here with community schemes is we're finding that a lot of the newer larger community schemes, they might have 20, 30 particular development lots. Like we manage a site out at Wentworth Point, which has around about 20, 25 development lots when the whole development is finished. So lifting the number to 15 means each development lot, which in that particular case is a strata scheme, so there might be a block of 200-300 units. Previously, they might not have been able to have a voice on the strata committee. Under the new legislation, lifting it from 9 to 15, gives, I guess, essentially an extra 6 lots the potential to have a say at committee level. So, sorry, just thought I'd jump in.
Yeah, no, thank you. There you go. So our committee, yes, there's a couple of changes to the election of committees and that type of thing. So first of all, a committee member can be excused from voting if there's a conflict of interest. Okay, so previously with the election of the committee motions, if someone was a conflict of interest, they would need to declare that. So if they were a relative or had a pecuniary interest or something like that, they would just need to disclose that, and then they could vote. So what this new legislation is stating is that they must be basically abstain or be excused from voting on the election of the committee motion if they have a conflict of interest. Okay, so that's
another example there too. Sorry to jump in, Josh. Yep. When there is a strata committee deciding a particular matter, like let's say, for example, you're deciding on the change of cleaner, and one of the committee members recommends their sister who runs a who runs a cleaning company, or their brother or something like that. Under the current law, you just have to disclose it. Under the new proposed laws, if you're voting on an item and you have a conflict of interest, and the Act defines what that looks like, then you would have to be excused from voting on that particular motion. So rather than pushing your relative's company in or something like that, you would have to sort of be excused or abstain from voting. Yeah.
Perfect. All right. The removal of the Strata committee member will now be by ordinary resolution and not special resolution. Okay, so if there were to be any changes, if a meeting was called to remove a member or members from the Strata committee, usually that would be a special resolution. That's now changed to an ordinary resolution. And the other part of this as well is if someone is removed from the Strata committee, they basically cannot be on the committee for another 12 months. So obviously, if you are having that meeting sort of outside the AGM, where we normally have the election of the committee, it's basically 12 months from that date. So if you were 6 months in and the committee member wasn't working out, there was a motion for that. If they were removed, 12 months until they are eligible again to be on the committee. So a bit of a change there.
And just to highlight that, I have had clarification from government on that one, that is 12 months from the resolution being made.
Resolution, yes.
Yeah, so for example, if let's say you had a troublesome committee member, there was a general meeting, they were voted off the committee tonight, and let's say the AGM was due to be in January, under this legislation, they couldn't stand for the committee or be elected on the committee at the AGM in January. They'd have to basically take a seat on the bench for 12 months. So that we've actually had a couple of examples of that where owners corporations have voted somebody off the committee, and then the AGM's the next month or the following month, and then they're sort of back on, and there's issues and disputes and those sorts of things.
All right. So yes, there were a couple of changes there, and a couple for the committees as well. So where it's called for an election for the committee, what Andrew said just before, can take place at a general meeting and not just the AGM. So that's good to know there. And Andrew, I'll throw this question to you. Why do you think this might be helpful?
Yeah, look, we often find that potentially throughout a year we might get vacancies on the Strata committee. So let's say, for example, we had 9 people on a Strata committee, and let's say 3 of them sold in the first 6 months. So 9 goes back to 6. The act requirements and how you pass motions at the Strata committee, and there's always been debate around, well, the number at the AGM was set at 9, so the quorum and those sorts of decisions are based on that particular number. So what they're saying here, and my reading of the legislation, is basically that if you needed to hold an election throughout a year, rather than waiting for the AGM, you could have another election for a Strata committee at a general meeting. So other general meeting apart from the annual general meeting. So this allows a bit more flexibility. It allows also a bit more clarity. I do like this particular reform. I think it just makes it nice and clear that if you do want to redetermine the numbers on a Strata committee, because potentially you might have had 9, a bunch have dropped off, and you just don't have the interest, so you can redetermine that number so that you can have a functioning committee thereafter. Or again, if you're seeking to replace a vacancy, then it's nice and clear that it's required to be at a general meeting. So previously we've had some schemes that would do that at a Strata committee level, and there's been debate in Strata land whether that is okay or not. This change makes it crystal clear in my view. And sort of moving on from that, so another Management Act change is that all records are to be kept electronically. Now, I'll throw this question out there to our Strata owners on online this evening. Do you think this is common practice at the moment? I have to say, certainly it is with Netstrata. I've been at Netstrata for 16 years, and all of our documentation is held electronically. So when we take over a Strata scheme from another Strata company, often we're delivered with cardboard boxes full of records, and then we sit there for months scanning documents, trying to find the insurances and this sort of thing. And basically what the legislation has done is basically played catch up and said, well, you know what, we're in the 21st century, let's move on from clag glue and scrapbooks, and let's have documents held electronically. Yeah, just interested to see if you think that's common practice, because you'd actually be quite surprised how antiquated some practices are out there in Strata land, that there's still people with minutes books, sticky taping A4 sheets of paper from their Strata committee meetings and that sort of thing. So yes, it is quite interesting. I also note that an item that we're not talking about this evening is how Strata Managing Agents basically pass books and records on to another Strata Managing Agent, etc., where they're terminated and those sorts of things. There has been changes in the property and stock agents regulations that basically say, well, there has to be proper transfer of records, and if Strata schemes are self-managing, there's got to be a process in place to obviously explain the books and records and sort of more or less teach them what they need to do thereafter. So this sort of piggybacks off the back of that reform. The next one there, tenancy notification. So basically, under the banner of keeping or good housekeeping and good record keeping, tenancy notifications for a Strata role obviously are quite important. So when a change of tenant occurs, it's imperative that the managing agent is informed of the change. So under Section 258 of the current legislation, it says, well, within 14 days of signing a lease, basically the owner or the owner's agent need to inform the owner's corporation of the new tenant. So there are penalties, obviously, to leasing agents for not doing that. Also, tenants may provide their own notice under these new regulations. So currently, as I said, it sits with the landlord and the landlord's agent, but this may move on to the tenant's side of it, which is going to be, I guess, a difficult thing for us to verify. If someone says, "Oh, look, I'm the new tenant of Unit 1, 2, 3, 4, 5," obviously there's going to be certain processes that we put in place. For example, please give me a copy of the lease and those sorts of things so we can verify that. But obviously that is a step forward, in terms of, obviously allowing tenants to update the details, etc., with us. All right, the next one is a little bit of a curly one. So basically company nominees. I'll explain to you what they are. So there's changes to extending basically the proxy limits to company nominees and powers of attorney. So if you know what a proxy is, basically what a proxy is where you cannot attend a meeting. Let's say you've got an AGM tonight, you can't go, you can send a proxy. So you can basically appoint your brother, your sister, your cousin, whoever it may be, to attend that meeting on your behalf, and they basically vote in your capacity. A company nominee is different. So a company nominee is where a company, and I'll show you on the screen an example, is where a company owns a lot, not an individual. So here on the screen, I've just mocked up, a 10-lot strata scheme, lot 1 to lot 10, and pick some random names. And you'll notice that lot number 3, 6, 7, and 10 are proprietary limited companies. So for those companies to exercise a vote at a general meeting, they would require a completed company nominee form. So a company is not a living and breathing human. They can't vote at a meeting. They've got to appoint a human to obviously vote on their behalf at the meeting. So that is basically what a company nominee form is. Now, the changes in the Act are actually, I had to read it a couple of times to sort of get my head across it, but basically, fundamentally, it is imposing similar rules that proxy holders have, where they can only give 5% of the number of lots within the strata scheme, basically a proxy. So how that works, if you had a 100-lot strata scheme, one individual can only turn up and represent 5% of the number of lots, so 5 out of 100 schemes. So slightly different here with proprietary limited companies. So if you, let's say, for example, if you're Elvin Superannuation Fund and you have 3 lots within a 10-lot scheme, if it was a proxy, basically you would be limited to only exercise 1 vote. Now, that I'm reliably informed that's not the case with company nominees. So if you own 3 lots and you're the company nominee, it's your superannuation fund, you can turn up and exercise the vote. However, you're limited to then exercise the vote of other companies, etc., beyond, as I said, 5% of the number of owners in the scheme. So the proxy legislation says number of lots. The company nominee legislation says, or changes, number of lot owners. So slightly different definition there. So if you're confused and you have a lot that's owned in your superannuation or your business name, feel free to reach out to us. But I'm reliably informed, there'll be basically no change to the way that you exercise your vote. The change will be if you're exercising your vote for your super fund or proprietary limited entity, as well as other proprietary limited entities, there may be caps placed on how you exercise the vote for those additional, as I said, proprietary limited companies, just like the proxy law. So if I've confused you, feel free to reach out. More than happy to sort of, explain that further. Now, moving on, Management Act bylaws. So this is a big one. So all historical bylaws must comply with current law. So we saw this a couple of years ago where, there was basically a blanket ban on having a no pets bylaw, for example. So the Cooper case saw the outlawing of basically non-pet bylaws, and I got a little pooch on the screen there as an example. And basically this particular change is saying, well, hey, all of your bylaws need to comply with current laws and legislation. So it's going to be an interesting one to see how that plays out. So if you've got older historical bylaws sitting on your title of your owner's corporation or your strata scheme, you might think to have a review of those and just see which ones, I guess, potentially would fall out of bed with the law and potentially be overturned. So again, that's going to be an interesting one to see how that plays out. Okie dokie, just moving on to a couple of things in relation to managing agents and talking about the finances of the scheme. So under this one, there's quite a bit to unpack. So the first one is the notice of the renewal of the agency agreement notifications are going to be tightened up. So the way in which a strata managing agent would notify of the end of their agreement. There's slight tweaks in how that is to happen. And also, there's a standing for fair trading, which this is going to be interesting again to see how this plays out. Standing for fair trading in NCATs. If you don't know what NCAT is, New South Wales Civil and Administrative Tribunal, to apply for compulsory appointment of a managing agent. So basically, of a strata scheme. So what a compulsory appointment is, if a strata scheme is deemed to be dysfunctional, so let's say they can't make a decision, or something like that, or potentially their warranties are going to run out, they can't make a decision. Basically, a lot owner, as the law stands today, can run off or make an application to NCAT and say, hey, we need a compulsory manager. Now, that compulsory strata managing agent basically has all the powers of the owners, or most of the powers of the owners corporation. So generally, they don't need meetings to raise levies. They're there to basically be the mum and dad of the strata scheme and sort of sort the mess out, for want of a better explanation. So the change here is that fair trading, may be able to have those powers rather than needing an application. They might look at an owners corporation and say, look, this is dysfunctional. Bang, we make a ruling that it be under compulsory management, which, as I said, currently sits with an application needing to be made. So NCAT might have that power to do that themselves. Clear rule on fund transfer. So this is an interesting one. Admin fund and capital works fund. So over the years, you might have built up a bit of money in your administrative fund, and you're looking at the capital works fund plan. You think, you know what, we're a bit short on that particular fund. Let's move a bit of money over. There's been a bit of a grey area in Strata where there's a piece of the legislation that says, if you borrow from a fund, so for example, if the capital works borrows from the admin or the admin borrows from the capital works, you have to return that money within a 3-month period, right? So, and again, there's been argument in the strata sector that when you generate your next quarterly levy, effectively you're paying that money back. So here there's going to be changes to the way in which funds are dealt with, and funds can sort of flow from one fund to another. It's not uncommon for owners corporations to, have a surplus in the administrative fund and want to transfer that to the capital works fund practically to obviously make the, balance the books, as it were. There's also going to be a difference in emergency levies. So the final point on the screen says grace period for special levies. So 30 days to 14 days for urgent safety repairs. So currently, as it sits here today, if you're issuing a levy notice, you need to give a lot owner 30 days notice of that levy and when it falls due. And they also have 30 days grace. So this would change to 14 days, respectively, for urgent safety repairs. So let's say, for example, you've got balustrades falling off, or you've got defects that you need to get remedied, you've got water coming through a unit or something like that. You can actually give a shorter notice period and a shorter grace period for those particular levies, obviously to balance the cash flow. All right, another one here, which is quite interesting, and it has been in place for large schemes for a number of time, since the 15 Act, actually dates back to the 96 Act. Basically, expenditure that has a value of $30,000 or more, you need more than one quote. So the legislation currently says, so without this amendment, it says for a large scheme, so 100 lots or more, are required to have basically, 2 quotes or more for any expenditure over 30,000. Now, a lot of strata schemes decide that they will not comply with this rule, and you can do that under Section 102 of the legislation. It does say, look, owners corporations can pass a motion to disregard that rule, and many do it because you might have large expenditure, and if you were to get quotes and have to bring that back to a general meeting or a strata committee meeting, that might slow down the repair process, etc. For example, you might be doing a fire inspection. There might be $40,000 worth of repairs. You really sort of got a tight time frame. You've looked at the quote and it looks fair. The strata committee want to approve it. Under the new legislation, regardless of the size of your building. So currently it's 100 lots or more. The change will be basically, it will affect all strata schemes from 2 lots beyond, whereby you'd have to have a minimum of 2 quotes, as I said, for any expenditure, $30,000 or more. All right, moving on. Pets. Let's talk about pets. So basically, extending the strata reforms to community properties. So if you're an owner in a community, a neighbourhood, or a precinct association, the same rules around the fairness and the, as I said, basically the blanket ban on bylaws that rule out pets and say you can't have pets. that will be transferred over to community lands. There's also a new change that's saying, hey, let's prohibit fees, bonds, or mandatory insurance as a condition of keeping, a companion animal. So some schemes that say, but potentially might not be too keen on animals have said, look, you need to have a bond of $500, and therefore, if your dog eats the carpet in the common area or something like that, you could use that bond to remedy the breach. You can no longer charge fees or bonds, all those sorts of things. The change will also prohibit bylaws that restrict assistance animals from performing their duty and assisting. I guess why would you? The final one there, specify acceptable forms of evidence of assistance animal status. So that's going to be clarified in the regulations. All right, the next one there, the Management Act, the bylaw enforcement. So if you're not aware of how basically bylaws are policed or pursued for those who breach them, I'll show you in a moment. But basically, there's this section in the legislation, section 146, and basically what it is, it's designed to be basically the final warning to a lot owner or an occupant, tenant, and whatnot, that they're breaching the bylaw and they need to comply with the bylaw. So what are the bylaws? They're the rules and the obligations that the occupants and the owners must live by. So, for example, noise. Don't create a noise that disturbs your neighbour. Let's say you've got, party in a particular lot. You've sent them a polite note. You've sent them another polite note. The strata manager's written to them. Section 146 currently says, okay, the owner's corporation can basically decide to issue a notice to comply, and that's generally we issue the standard document that the Office of Fair Trading issues on their website to basically say you've breached the bylaw by having 27,000 parties in the month of November, or what they sound really busy, don't they? Or that sort of thing. So 146 clause 4 is going to be amended to basically pass this power to the strata managing agent, should they be delegated the right to do so. Now, you might think, oh, that sounds dangerous, that strata manager can just send notices to comply and take everyone to NCAT and get them fined. I disagree. I think this is streamlining the process, and it's better for the administrative processes of following up bylaws. And let me explain what I mean by that. First and foremost, and let's just say we've got a typical parking breach or a noise breach. What generally happens when we pursue a bylaw is that we gain evidence of the breach of the bylaw. We obviously notify the individual that they've breached the bylaw. And then generally, most strata managing agents give it around 3 warnings, and then the matter is moved on to what we call a notice to comply under section 146. Now, currently, as it states, the owner's corporation serve that notice. You'd have to have a committee meeting or a general meeting for the most part to do that, unless you're delegated that right under your agreement. The change is going to do exactly that, allow you to be delegated the right to serve that notice as a strata managing agent. So it just clarifies that ambiguity. So a lot of agents over the years have done this, and it's in their agency agreements, and there's been dispute whether they had authority or not. Now the law is tidying that up to say if they have authority under their agency agreement, they can do it. Now, why is this helpful? You can imagine if you've got a large scheme of 100, 150 lots, and you've got someone parking in the wrong spot and you want to serve them a section 146 notice and take them to the Office of Fair Trading, you'd have to have a committee meeting. Committee meeting notices have to be posted out to all large scheme owners, and therefore the owner's corporation incur a cost. So it might be several $1,000s worth of paper and postage, etc. However, if the agent can do it, they don't need a committee meeting, and therefore can, let's say, liaise with the committee over email, and let's say there's a consensus, they can use their delegated authority to serve that notice, which, as I said, just makes that administrative process a little simpler. Now, generally what would be, the general consensus or practice out there in the industry would be that we would ratify that decision that was potentially made by email or made by the strata managing agent at a future strata committee meeting or general meeting of the owners corporation. So basically the process is, we get evidence, we serve that notice, and we decide, okay, are we going to go down the route of mediation, or do we apply to NCAT for a breach to a notice to comply, which can then attract a penalty notice to the offender of up to $1,100 or $2,200 for a repeat offence within 12 months. So hopefully that makes sense. As I said, I think personally it's a step forward to allow this to happen without the need to have a particular formal meeting. All right, moving on to the building law reform. So basically, in this particular instance, there's been a change, or there's something that's obviously passed to give the legal duty and fair trading regulatory priority to basically deal with owners corporations that are not maintaining the common property. So new powers in 2024. Fair trading will be able to respond to the failure of an owner's corporation to repair and maintain common property and issue them with a notice to comply, a rectification order, and penalties. So this is, again, going to be interesting. So if you've got an owner's corporation that refused to repair a common property, potentially there might be a leak or something through the roof, or they're just dragging the chain because things are expensive. Potentially the Office of Fair Trading have more powers to make sure this stuff happens. So the New South Wales Office of Fair Trading basically want to help owners corporations comply, but there obviously must be consequences for neglect. So if there's owners corporations out there that don't want to fix anything, potentially they may be in trouble. All right, now I'll just put it out there, Josh. Was there any questions that you wanted to throw on the live chat there? Anything potentially?
Yeah, I've got a couple for you actually. The first one was sort of surrounding the the conflicts of interest and that type of stuff. So there's a question there about building managers and being on the committee, and also a lot owner.
All right, so a building manager can be on the committee provided they own a lot in the scheme and they've disclosed that they're the building manager of the scheme. So those two things have to happen. So they have to be an owner in a scheme. And this is actually quite common, back probably 10, 15, 20 years ago, before the 2015 Act came in play. Basically, there was I won't name the name, but there was a large developer that basically used to set up a management lot. So they used basically in all their developments, they had really big schemes, and they would put like a reception area, and they would basically call that the management lot, and you would buy the management right to the building. And a lot of the time, if you were the building manager, you owned that lot, so you bought the management right, and you bought obviously the right to be on the committee, contribute, and those sorts of things. And again, as I said, the 15 Act said that basically you have to own a lot and disclose that you're the building manager. So if you don't own in there, in the scheme, you're not entitled to be on the Strata Committee. Also, if you're a property manager or leasing agent and you do not own in the building, you cannot be on the Strata Committee. You have to obviously own, and again, the same steps. You have to own in the building and disclose that you're a leasing agent for one or more of the lots. Any other questions there, Josh?
Yeah, because there's been a couple of things on units of entitlement and that type of stuff. There was one question about changing units of entitlement, basically for strata, also for residential and also BMCs.
Interesting one. Okay, so how do you do it? So the law basically says that your units of entitlement, basically the way in which they're changed is an NCAT order, New South Wales Civil and Administrative Tribunal, and they will generally order the units of entitlement to be changed if one of two things can be satisfied. So the first thing is that the units of entitlement were wrong initially, so they've calculated them incorrectly. Or secondly, they become wrong over time. So potentially you've had a subdivision, and therefore that's thrown the way in which the lots are valued amongst each other. So the standard process would be that an owner's corporation or an individual lot owner, if the owner's corporation don't want to go down that road, go out, get a valuation, basically get an opinion from a registered valuer to say, okay, the units of entitlement should be, as follows. And generally NCAT allow a bit of leeway for human error, right? So obviously my opinion might be different to yours. If you're valuing the scheme and I'm valuing the scheme, we might be a couple of dollars or, a couple of units of entitlement different. So much like, a sales agent. So if a sales agent says, look, your property's worth $1 million and you only get 500, well, they're probably going to be in trouble. If they say it's worth $1 million and you get 980,000, well, they say, well, that's within the margin of acceptability. So that similar rule would apply with the change of units of entitlement. So NCAT would consider that potentially the incoming valuer might have a different opinion to the previous valuer. Any other questions there, Josh?
Just sort of, I think you mentioned it before, but there's a question about a property manager and can they be nominated to the Strata Committee? I think you sort of touched on that before.
Yeah, correct. They've got to own in the scheme and they've got to disclose. Yeah.
Yeah. Yeah.
Alrighty. So we might just move on just to sort of talk about, so we've got just under 10 minutes and I'll sort of talk you through phase 2 of the New South Wales strata law reform. So all the stuff we've been talking about has been passed. We're just waiting for basically the commencement date once it is, gazetted at law. Now, phase 2, there's a series of things that the government are looking at, and generally speaking, a public consultation process would ensue, and obviously, owners are invited to throw their opinions in. All right, so I'll walk you through what they're looking at. So bigger challenges, they're also informed by SCA New South Wales and the Strata Commissioner roundtables around sort of the concerns in the industry. So they're looking at tightening up developer compliance around off-the-plan representations and the initial maintenance schedules. So if you don't know what an initial maintenance schedule is, it's basically a plan that the developer is required to put forth that shows basically the maintenance required to the building in order for the warranties to stand up. So, for example, if you bought a new unit, your owner's corporation did nothing, didn't maintain anything for 5 years, and all of a sudden everything started to break down, the developer could say, well, hang on, you didn't maintain your building. Whereas if you have an owner's corporation that maintain everything, get things serviced, there's preventative maintenance measures in place, then there's obviously the potential to say, well, look, we've maintained our property, something has broken that potentially, may breach the warranty provisions, etc. So there's going to be some tightening up of that. Capital Works Fund planning, so the minimum requirements around that. So you might notice out there in the industry might be some variances in terms of what a Capital Works Fund plan, looks like. Generally speaking, they're pretty standard. It might be a spreadsheet which says, all right, in year 1 to year 10, what you should be putting away in your capital works fund to meet those future needs. So they're looking at minimum requirements and templates, etc. Also, embedded networks and other supply contracts. So I believe in Victoria, there's been a lot of tightening up around embedded networks. And if you don't know what an embedded network is, it's basically where a particular better, for want of a better term, a supplier of energy or gas or whatnot, basically has a contract where they supply that particular utility to the building, to the common areas, and to the lots. And generally speaking, they provide infrastructure on the way in. So, for example, you might have a hot water embedded network that gives the owner's corporation, a maintenance plan over 10 years, but it almost seemingly looks like it locks in lot owners to only be able to use that supplier. So there was changes a few years ago which said, well, look, all embedded networks must have meter numbers given to lot owners so they can go out there in the market and use other suppliers. So you are not locked into an embedded network. But there is still a lot of complaint out there in the strata industry around these longer term contracts. And I believe the government's looking to tighten that up. First AGM record being updated to the Strata Hub. If you don't know what the Strata Hub is, it's basically a government portal whereby the information for an owner's corporation is loaded. And basically it is things like your capital works fund amount, how many lots are in the scheme, who's on your strata committee, etc. And they're looking to add any first AGM records to that hub. Also, there's going to be a prohibition on unfair contract terms. So, if you've got a contract term or condition that is unreasonable, that might be grounds to get out of that particular contract. Also, committee education and empowerment is going to be a feature of phase 2. And I'm actually excited by that. If you don't know, Netstrata runs Strata Committee training. And so we pass or propose motions at your AGM, and likely if you've had your AGM with us this year, you've considered that motion. I'd encourage you to agree to it. I believe it will be mandatory at some point to do some form of committee education or training. And really, we're trying to help you. We're trying to educate you on the on the sector and what's happening out there, and obviously take your questions and concerns. And we're very open to any particular topics that you would like us to talk on or investigate on your behalf. So what's next for phase 2? As I said a moment ago, we're looking to possibly receive the invitation for public consultation, which generally speaking, they go out to industry bodies and basically say, what do you think about these particular reforms? The next step would be that they put together draft legislation or a draft bill, which would then again go out to public consultation, and then generally shortly thereafter once they've received the feedback of industry bodies, owners, etc., owners, corporations, committee members, those sorts of things that have put a submission in, that bill would then go to Parliament, obviously be voted on at the state level. So how will these changes affect your schemes? Well, I'm glad you asked, or I asked that question of myself. Here's some sort of key points. So the things that hopefully you've picked up is they're looking at more, right? What I mean by that is more notice periods, more notice for meetings, so people are well informed and can consider what is coming up. Also, more transparency for conflicts of interest. So we've talked about that at a few levels, at developer level, at strata committee level, etc., for contracts and those sorts of things. Also, more accountability to agents and committees. So accountability on how you could potentially be on the committee or voted off, or those sorts of things, and also some tighter financial guidelines, again, around that $30,000 mark, to make sure larger expenditure, there's due process, there's tenders obtained, and those sorts of things. And look, I'll throw this to you, Josh. Out of all the things that we've talked about tonight, what's the sort of key takeout for you as a strata manager?
Yeah, so obviously the items on the committees. So we're just going to be mindful of that when we're having our meetings, and if there's any issues with the committee throughout the year. The community plans with the 15, that's the extra 6 members that they can have on the committee. That's an interesting one. I think for me, the main one is the notice of the meeting. So obviously, as a strata manager, that will affect every strata manager in the industry. Obviously, planning your year and month and all that type of stuff with meetings that we have, it's going to change it a little bit. Just make sure that we're allowing for basically that 3.5 weeks before we send out. So yeah, I think that's probably the main change there.
Yeah, I do agree, Josh. The timing around the AGM, so everybody understands, there's generally a pretty tight window between the end of your financial year and your next levy cycle. So for basically for the financials of a building to run seamlessly, you have to have a timely AGM. No delay. Have your meeting, decide on your next budget. Obviously, issue levy notices to your owners, etc. If you extend that time, even just that additional week, it just means it's a little tighter of a process to sort of fit in. And yeah, obviously we've got to work with our owners, corporations on any of those changes. And just sort of last little call for questions out there. Is there anyone that had any sort of dying questions that they'd like to throw at us? I know we've had a massive amount of questions here.
It's been quite a lot. Sorry, I didn't get to all of them. We got to most of them, but yeah, there are a few there that we missed out on.
Yep. So just a couple of things here. Yes, this webinar is recorded. Let me just have a look. Okay, we've got a question here from anonymous attendee. So what is the legal position when an owner rents out their unit but not the garage, and then uses the garage to store dangerous goods? Okay, so generally your bylaws prohibit the storage of flammable or harmful goods. So number one, that could be potentially a bylaw breach. You generally can't restrict the use of a lot. So if somebody rents out the unit but not their car space, and let's say they park a vintage car in there, or they some push bikes or something, or their boat or something like that, you couldn't stop that. If they only lease the unit out and not the car space, that's fine. But if it is a situation where there's flammable goods, then potentially there's a bylaw breach there, and again we would follow that process. Let's have a look. Question here from Gary: can't a property manager of a lot be nominated by the owner to be on the committee? No, only if they're an owner. Is basically the way that the current legislation reads on that one. Unfortunately, I don't necessarily agree with the law on that. I think I had a lot of property managers back in the day that were great on strata committees and represented the thoughts and feelings of a lot of owners. It was good to have them on the committee. Then the 15 Act came in and said, well, look, sorry, you've got to be an owner within the scheme to be on the committee. So, yeah, unfortunately. All right, how an owner can nominate to be a member in owners committee. So the strata committee, basically how it works is the legislation requires a motion at every annual general meeting. Prior to the annual general meeting, we will send out a survey to ask whether owners would like to be on the strata committee. And if they say yes, we obviously pop their name on the agenda, and at the AGM, those members can be considered, as well as anyone present can obviously if they're eligible to vote, they can obviously nominate to the committee. Eligible to vote basically means you've paid your levies, you're an owner there, you've got authority, you can obviously put your name forward to vote. If you haven't paid your levies, unfortunately, you can't be on the committee. But as I said, that pre-nomination process or at the meeting. Anything else there, Josh, before we sort of close up the webinar this evening?
That's it. Yeah, I'd say that's it.
All right, very good. Well, we'll go through the questions and sort of pick out if there's any common themes and issue potentially a paper with the recording of this particular webinar. Just a couple of final things before we close up. Just a reminder, we do have a wonderful, relatively new app. So the app's been around a while, but we've got a whole bunch of new features loaded on there. So feel free to scan the QR, download the app. You can see your financials. You'll soon be able to see your levy notices, documents for the owners corporation, those sorts of things. And just bear in mind, we're on all the usual social media channels. So we've got a YouTube channel, so all of our training and sort of webinars and videos and that sort of thing is uploaded there. So feel free to look for Netstrata there in the search field, as we are on obviously Facebook, Instagram and LinkedIn and so forth. So we'd love you to follow us. Thank you so much again for your time and commitment to log on and listen to all things legislation. Hopefully we've kept you awake for just over an hour. Appreciate your time, and obviously if you bump into owners in your strata scheme that couldn't make it tonight, encourage them to watch the video. Very good for them to obviously be informed on the upcoming changes to the legislation. Final thank you to you all, and a thank you to my colleague Josh for jumping on this evening.
Thank you.
Thank you, everyone. Have a lovely evening, and we'll leave you to it. Thank you.
Good night.